Good evening, everyone, and welcome to RFL. I'm Richard French. It is a historic day in Washington. That is, the Senate kicks off only the third Senate impeachment trial for a president of the United States in American history. And as expected, it started off with a lot of arguments and fundamental disagreements, but there were also some big developments. And to get more on those, let's go to Serena Marshall. She joins us live from Capitol Hill with the latest.
Good evening. On this historic day here on Capitol Hill, debate continues over the rules that will govern only the third impeachment in American history. The first vote falling along party lines, but that came only after some major concessions by the majority leader to members of his own party.
The Senate will convene as a court of impeachment.
The trial to impeach President Trump underway on Capitol Hill.
All persons are commanded to keep silent on pain of imprisonment.
As the two teams debate the rules for the trial. What have they agreed to? Each side getting 24 hours over 3 days to make their opening statements, followed by up to 16 hours of questioning from senators and the evidence from the House automatically admitted into the record. But big disagreements remain, namely on new witnesses and evidence. The First Amendment to compel evidence from the White House.
It's remarkable that after taking the action of the breathtaking gravity of voting to impeach the duly elected President of the United States, and after saying for weeks that they had overwhelming evidence to support their case, the first thing that the House managers have done upon arriving finally in this chamber after waiting for 33 days is to say, well, actually, we need more evidence.
We are ready. The House calls John Bolton. The House calls John Bolton. The House calls Mick Mulvaney. Let's get this trial started, shall we? We are ready to present our case. We are ready to call our witnesses. The question is, will you let us?
Debated for nearly the full 2 hours, falling along a party line vote. The next amendment to the rules, subpoenaing certain documents from the Department of State.
We're told the minority leader has several amendments he intends to introduce, but even if all of those fails, the fight over witnesses is far from over. Remember, after they go through opening statements and after senators have an opportunity to question both sides, there'll then be an up or down vote again on witnesses. President Trump did weigh in from overseas, writing simply on Twitter, read the transcripts. Live on Capitol Hill, Serena Marshall, ABC News.
All right, Serena, thank you very much. Now, we're going to spend the balance of this hour, obviously, discussing impeachment from several different angles. What we're going to do is we'll take a look at what the Founding Fathers intended. There's a lot of debate about where the Senate can't go, should or shouldn't go, and also we'll look at not only what they intended, but also where we, the people, stand on this issue to this point. Latest polls give us a pretty good snapshot on how voters view the process and the evidence that we know already. Also, the schedule and when things could wrap up. It's a big if here. We will see a resolution, will we, before the State of the Union address on February 4th? Right now, anyone's guess. Then, the politics of impeachment. We'll talk about that with our friend over at ABC News, political director Rick Klein, who's got his pulse on what's going on behind the doors at Capitol Hill. But before we get to our first guest, let's dip in to the trial live now on the Senate floor. Val Demings, Democratic Congresswoman from Florida and one of the House managers.
This amendment. And Mr. Chief Justice, the House managers reserve the balance of our time.
Mr. Cipollone.
Thank you, Mr. Chief Justice. In the interest of time, I won't repeat all of the arguments that we've made already with respect to these motions. I would say one thing before I turn it over to my co-counsel. Mr. Schiff came here and said he's not asking you to do something he wouldn't do for himself. And the House manager said, we're not asking you to do our jobs for us. And Mr. Schiff came up here and he said, I call Ambassador Bolton. Remember Paul Harvey? It's time for the rest of the story. He didn't call him in the House. He didn't subpoena Ambassador Bolton in the House. I have a letter here from Ambassador Bolton's lawyer. He's the same lawyer that Charlie Kupperman hired. It's dated November 8th. He said, I write as counsel to Dr. Charles Kupperman and to Ambassador John Bolton. In response to the letter of November 5th from Chairman Schiff, Chairman Engel, and Acting Chair Maloney, the House chairs, withdrawing the subpoena to Dr. Kupperman. I mentioned that earlier. And to recent published reports announcing that the House chairs do not intend to issue a subpoena to Ambassador Bolton. He goes on and says, we are dismayed that the committees have chosen not to join us in seeking resolution from the judicial branch of this momentous constitutional question. And he ends the letter by saying, if the House chooses not to pursue through subpoena the testimony of Dr. Kupperman and Ambassador Bolton, let the record be clear. That is the House's decision, and they made that decision. They never subpoenaed Ambassador Bolton. They didn't try to call him in the House, and they withdrew the subpoena for Charles Kupperman before the judge could rule, and they asked that the case be mooted. And now they come here and they ask you to issue a subpoena for John Bolton. It's not right. I yield the remainder of my time to Mr. Sekulow.
And they had a very brief snapshot you just heard there from Ms. Cipollini, one of the basically two co-counsels that we've heard so far today, Jay Sekulow, who you see on your screen right now, and Cipollini have been making the argument basically for the president. And conversely, we've been seeing primarily from Adam Schiff, but also from a few of the Democratic lawmakers, Zoe Lufner, as also Val Demings, as to arguments as to why witnesses should be so critical to this process, as well as documents that should be made available as well. I want to bring in our first guest, former Federal Prosecutor Joe Moreno. He served in the Justice Department's National Security Division. He's helped us throughout this entire process, and now we are at the, well, trial phase for all intents and purposes. So, Joe, a lot to unpack today, but first let me start off with what the Founding Fathers intended, because clearly we've had two different perspectives, depending on the lawyer speaking on behalf of one, their client, and also on the other, the Democrats looking for discovery. First off, is this a trial for all intents and purposes? Because I want to start with a clip, and this goes back to the Clinton impeachment, and then Senator Harkin, Democrat from Iowa, was looking for a point of clarification for the presiding judge, Chief Justice Rehnquist at the time, about who the senators were and also their role. Let's roll a clip.
I do not believe it would be a valid precedent to leave for future generations that we would be looked upon merely as jurors, but something other than being a juror, and that's why I raise that objection, Mr. Chief Justice.
The chair is of the view that the senator from Iowa's objection is well taken, that the Senate is not simply a jury, it is a court in this case, and therefore counsel should refrain from referring to senators as jurors.
And it's a distinction with a difference, isn't it, Joe, as to what the role of these 100 men and women are right now, because it's not just to be passive vessels and decide at the end yes or no. The Founding Fathers intended for them as the one bulwark to a president. This wasn't supposed to be a criminal court of law. They had a specific purpose that the Founding Fathers intended when it came to impeachment.
Hey, Richard, always great to join you. That's a really good clip, and I think it does open up the door to a pretty good discussion about the dual purposes that those 100 senators have on their shoulders throughout this process. One, to your point, they should be impartial jurors, right? That's the oath that they took, that they will listen to the evidence, judge it fairly, and come up with a conclusion. But you're right, at the same time, unlike a juror in a criminal trial, they're responsible for the process. They decide witnesses, obviously a critical issue, how long this process should take, how many hours in a day they go, decorum, evidence, documents, subpoenas, all of those things, and they are also expected to conduct themselves in that fashion in a fair and impartial way. So it's not like a juror who, like you said, can sit back, listen to the facts, and expect that the judge and the process is all basically locked in place. We're counting on those 100 senators not only to look at the evidence fairly, but before they even get to that point, to have a process that is fair, so that we can look back at this however it shakes out and say, you know what? I may be happy with the outcome, I may not be happy with the outcome, but at least I'm happy that it was done in a somewhat fair and impartial manner.
So We don't know how this thing ends, obviously. It's very unlikely that there will be, 20 Republican senators that will vote with every Democrat to impeach the president. But the first question is the process for this trial, if you will, to even go forward. We already know there's going to be an extension, not to, days, 12-hour days. It'll go till 2 or 3 in the morning or something. It'll be spread out 3 days for each particular side, 24 hours total to make their cases. And then seemingly, assuming tonight there's not 4 Republicans to decide that they do want witnesses, that buck will be passed to the back end. And there seems to be indications, at least from one Republican, maybe even a second one, that they might be open to the idea of hearing for witnesses we haven't heard from as of yet from the House side. That's the process part. But the arguments that were laid out, and I'd love for you to give a little bit of clarity here, because there is, if you go back to Clinton, and there's a lot of differences between the Clinton impeachment and today, Joe, but one of them was, we had to divine what the Founding Fathers intended as to whether or not an affair, and lying about an affair, reached the level of a high crime and a misdemeanor in as such as it threatened the national security and well-being. In this case, and correct me if you disagree, we see the prescience of the Founding Fathers. They clearly identified a foreign country's involvement or interference in our elections could threaten our democracy, and they articulated that from the very beginning documents of this country. And they also articulated what the role of both the House and, more importantly, the Senate was in terms of being judge and jury in this particular case here, to look at this case and go forward. So this argument as to whether or not no crime, no impeachment, we kind of already have our answer if we're going to follow the Founding Fathers' directives, don't we?
Yeah, Richard, that's a good way to compare it. In the Bill Clinton case, we had a crime. I think the real issue was it a high crime or misdemeanor? And I think looking back, I think history has judged that it probably worked out the way it should. He probably should not have been impeached. He was not removed. And I think history, while perhaps opinions differ on his behavior and how he would be judged today, at the time, it seems like it was the appropriate outcome. Here, where we may not have a specific violation of the federal criminal code, we do have the kind of behavior, call it abuse of office or abuse of power, that you're right. I do think it is the type of behavior the framers did concern themselves about. It has to do with a high crime or misdemeanor or high behavior at the highest levels of government that affects our military and foreign policy. And it has to do with the kind of behavior that honest people can differentiate about, but it does address the type of behavior, which it basically is, do we have an out-of-control executive? Is this a case where Congress should step in and use the most serious power it has, which is to say, we cannot approve of how you, the president, are conducting yourself? So I think people can differ on whether or not it rises to the level of removal. I think that's fair, and people can argue about that. But as far as whether it's the type of behavior impeachment was designed for, I don't think that's a close call. I think the answer is yes. This is Congress's power to assert itself, and it has every right to do so.
More clarification, because there's 3 principal pillars of arguments that I heard from both Jay Sekulow and Cipollini, which is abuse of power is some made-up standard. They also said that obstruction is not an impeachable offense, and that their client, in effect, the president, he was denied due process to this point here. Is abuse of power made up? Is obstruction considered no big deal, or at least not a major standard here? And didn't the president get a chance to make his case but chose not to participate in the House?
So I'll take each one of those. Let's look back to Richard Nixon's case, right? He was going to be charged, if he had stuck it out, with basically abuse of power. He was charged with misusing the Central Intelligence Agency to spy on Americans and misusing the Internal Revenue Service to harass American taxpayers. Technically, neither one of those were probably crimes because it's such a unique activity that's specific to the president. And yet, I think almost anyone would agree you can't have a president who's doing those things. So I think in that respect, how can you not say that that kind of behavior, which technically might not be a crime, is acceptable and something you would allow a president to continue to do? So I don't think abuse of power is made up. I think it's legitimate. It's a little amorphous, and that's where it is the responsibility of the House managers to define that and to argue forcefully how this president's conduct defies that standard, but I think it's legit. On obstruction of Congress, it's a little more nuanced. I think reasonable people can disagree on whether the House should have gone to court to enforce its subpoenas, or basically issue subpoenas and then carry them out, versus saying, we asked, the White House said no, and we're impeaching. I think there can be some vigorous debate on that point, and I think of the two charges, that is the weaker one. I think House Democrats are smart to focus on the abuse of power, the Ukraine-centric charges, less on the obstruction. As far as the third, look, complaining about due process, I wasn't too convinced when the Republicans complained that they didn't get due process in the House. I'm also, frankly, not too convinced by Democrats complaining now in the Senate. I think if the case is strong, and they do have a strong foundation here, it can argue itself, and I think the House managers are more than equipped to do that. So as far as the president now saying, well, the process is tainted now because I didn't get due process a few months ago, I don't think that's very convincing. And frankly, I wouldn't spend a lot of time on that if I was on the president's defense team.
Joe, stay with me. I got a couple more questions for you, but first I want to dip back into the floor of the Senate. Excuse me. We have Adam Schiff speaking specifically to issues we talked about, witnesses.
Part of the reason why they withheld the money. And when reporters said, well, you're kind of describing a quid pro quo, his answer was, yeah, get used to it or get over it. We do it all the time. Now, they haven't said they want to hear from Mick Mulvaney. I wonder why. The president did talk to Mick Mulvaney about it. Wouldn't you like to hear what Mick Mulvaney has to say? I mean, if you really want to get to the bottom of this, if they're really challenging the fact that the president conditioned $400 million of military aid to an ally at war, if Mick Mulvaney has already said publicly that he talked to the president about it, and this is part of the reason why, don't you think you should hear from him? Don't you think impartial justice requires you to hear from him? Now, counsel also referred to Ambassador Sondland, and Sondland saying, well, the president told me there was no quid pro quo. Now, of course, at the time the president said to Sondland, no quid pro quo, he became aware of the whistleblower complaint, presumably by Mr. Cipollone. And so the president knew that this was going to come to light. On the advice, apparently, of Mr. Cipollone, or maybe others, the Director of National Intelligence, for the first time in history, withheld a whistleblower complaint from Congress, its intended recipient. But nonetheless, the White House was aware of that complaint. We launched our own investigations. Yes, they got caught. And in the midst of being caught, what does he say? It's called a false exculpatory. For those people at home, that's a fancy word of saying it's a false, phony alibi. No quid pro quo. He wasn't even asked the question, was there a quid pro quo? He just blurted it out. That's the defense, that the president denies it. And what's more interestingly, he didn't tell you about the other half of that conversation where the president says no quid pro quo. He says no quid pro quo, but Zelensky needs to go to the mic, and he should want to do it, which is the equivalent of saying no quid pro quo except the quid pro quo. And here's what the quid pro quo is. He needs to go to the mic, and he should want to do it. That's their alibi? They didn't also mention, of course, and you'll hear about this during the trial if we have a real trial. Ambassador Sondland also said that we're often asked, was there a quid pro quo? The answer is yes, there was a quid pro quo. There was an absolute quid pro quo. And what's more, when it came to the military aid, it was as simple as 2 + 2. Well, I'll tell you something. We're not the only people who can add up 2 + 2. There are millions of people watching this can add up 2 + 2 also. When the president tells his chief of staff we're holding up the aid because of this, as the chief of staff admitted, when the president gives no plausible or other explanation for holding up aid that you all and we all supported and voted on a very bipartisan way, has no explanation for it, when in that call he never brings up corruption except the corruption he wants to bring about. It doesn't take a genius. It doesn't take Albert Einstein to add 2 + 2. It equals 4. In this case, it equals guilt. Now, you're going to have 16 hours to ask questions. You're going to have 16 hours. That's a long time to ask questions. Wouldn't you like to be able to ask about the documents in that 16 hours? Would you like to be able to say, counsel for the president, what did Mick Mulvaney mean when he emailed so-and-so and said such and such? What's your explanation for that? Because that seems to be pretty damning evidence of exactly what the House is saying here. What's your explanation of that, Mr. Sekulow? What's your explanation? Wouldn't you like to be able to ask about the documents? Or ask the House, Mr. Schiff, what about this text message? Doesn't that suggest such as what the president is arguing? Wouldn't you like to be able to ask me that question or my colleagues? I think you would. I think you should. But the backwards way this resolution is drafted, you get 16 hours to ask questions about documents you've never seen. And then you know what's more? If you do decide at that point after the trial is essentially over that you do want to see the documents after all, and the documents are produced, you don't get another 16 hours. You don't get 16 minutes. You don't get 16 seconds to ask about those documents. Does that make any sense to you? Does that make any sense at all? I'll tell you something I'd like to know that may be in the documents. You probably heard more about the 3 amigos. My colleagues mentioned 2 of the 3 amigos, Amigo Volker and Amigo Sondland. These are 2 of the 3 people that the president put in charge of Ukraine policy. The 3rd amigo is Secretary Rick Perry, the former Secretary of Energy. Well, we know from Amigo Sondland's testimony that he was certainly in the loop and knew exactly all about this scheme. And we knew from Ambassador Volker's testimony and his text messages and his WhatsApps that amigo was in the loop. What about the 3rd amigo? Wouldn't you like to know if the 3rd amigo was in the loop? Now, as my colleagues will explain, when we get to the Department of Energy records, that, well, surprisingly, we didn't get those either. But any communication between the Department of Energy and the Department of State is covered by this amendment. Wouldn't you like to know? Don't you think the American people have a right to know what the 3rd amigo knew about this scheme? I'd like to know. I think you should be able to ask questions about it in your 16 hours. At the end of the day, I guess I'll finish with something Mr. Sekulow said. He said, this was a dangerous moment because we're trying to rush through this somehow. It is a dangerous moment, but we're not trying to rush through this trial. We're actually trying to have a real trial here. It's the president that's trying to rush through this. And I have to tell you that whatever you decide here, and maybe this is wasted breath and maybe it's already decided, but whatever you decide here, I don't know who the next president's going to be. Maybe it'll be someone in this chamber. But I guarantee you this, whoever that next president is, whether they did something right or they did something wrong, there's going to come a time where you in this body are going to want to subpoena that president and that administration. You're going to want to get to the bottom of serious allegations. Are you prepared to say that that president can simply say, I'm going to fight all subpoenas? Are you prepared to say and accept that president saying, I have absolute immunity. You want me to come testify? Senator, you want me to come and testify? No. I have absolute immunity. You can subpoena me all you like. I'll see you in court. And when you get to court, I'm going to tell you, you can't see me in court. Are you prepared for that? That's what the future looks like. Don't think this is the last president if you allow this to happen. That's going to allow this to take place.
Your time
Mr.
has
Justice,
expired.
I yield back. I thank you.
And to bring back Joe Moreno. And Joe, it was the perfect dovetail, our questions, to what we just heard from Congressman Schiff, who, by the way, for whatever it's worth, and I know people have differing opinions, but without a note, I think has distinguished himself both on the Intel hearings and now also on the first day here up on the Senate. To that end, I think there's a lot of things that glaze over with the American public that don't have maybe the interest in this that you and I do. But people don't want to be kept in the dark. And the guy who says, I don't want to be a part of this drug deal, or talks about the president's counsel, Rudy Giuliani, that he's a walking hand grenade, you'd think he's got a role to play here that you'd want to hear his testimony. Of course, I'm talking about Bolton. He mentioned a few other of the relevant witnesses, including the Chief of Staff, Mick Mulvaney, or maybe one of the gentlemen over at OMB and the rest. If they run this thing through, and I know I'm getting a little bit into the political world, there is, I think, going to be a palpable sense, and the polls suggest, you didn't give us what we wanted. The American people wanted to hear from the relevant players and hear for ourselves what did or didn't happen and what should or shouldn't happen to the president. I think there's been a political miscalculation by McConnell, not just on how late this goes at night, but who we hear and don't hear from.
Well, Richard, I agree with you. I do think that Adam Schiff is probably one of the more effective advocates on either side of the aisle. He has courtroom experience, and he was a prosecutor, and I think he probably is one of the more capable, if not the most capable. Obviously, we're fighting about process here, and I do think that the Democrats have the moral high ground, to your point, because I do think that most people would say, let's hear the evidence and hear it out. I think that's a pretty good concept. Here's my concern. At some point, they're going to get their answer whether or not more witnesses will be entertained. If the answer is no, they have to be prepared to put on the case with the evidence they already have. So I wouldn't spend too much time talking about witnesses that are not in evidence, because you want to have the position as a backup, well, look, fine, you won't give us the witnesses we ask for. We still believe we have a righteous and viable case, and here's the evidence we do have. Here's why our case is righteous and we should win. So I think this can go too far. I think that in the next day or so, as the process arguments end and we get more into substance, Democrats are going to have to decide for themselves. Do we really keep going to bat for this additional evidence, or do we say, you know what, fine, don't give us what we want. We still believe we can win, and here's why our case should be, ultimately a vote to remove this president.
The only reason why I push back on that, Joe, is you already know the result. There is not a world, at least that I live in, where 20 Republicans are going to vote to impeach this president in the Senate. So if they already know it's, whether a couple come over, zero come over, whatever the case may be, they almost have nothing to lose. And moreover, I think the biggest factor that hasn't been discussed is Bolton's got a book. There's going to be FOIA requests. These documents are going to come out, and they're going to come out before November. Do you really want to be the Republican in Colorado, in Maine, in toss-up states here, where you have forfeited your political career to deny even the witnesses to appear, to go down for this guy? To me, if we knew there was nothing else coming out and is either they produce the witnesses today or it's over, I grant you. But this doesn't end with the vote, whether it's this week or next week. More will come out between now and then. And what do they do then, the Republicans, when they said, don't want to hear it?
Look, I get it. I mean, I think that I would rather be a Republican that can say with a straight face, I saw the evidence and I voted the way I did, versus I refused to look at a lot of the evidence and I voted the way I did. I would rather be in the first boat and say I at least was fair about the process. I just think that, to my view, I think the Democrats have the evidence to prove their case. So I wouldn't rely too much on what they don't have. I think the process argument's a good one, and they do have the moral high ground. But at the end of the day, I would say, all right, plan B, let's prove the case with what we have because we're confident in our case. And I think that's their backup position, and they should stand by it and be proud of it.
Joe, you always do a great job, and I appreciate your time here tonight here on a hugely important day in our nation's capital. Thank you again.
Be with you.
All right, everybody, when we come back, Andrew's going to join me. We're going to take a look where we, the people, the public, forget the 100 in Washington, where does the public stand on impeachment? And how about, do they want to hear from the witnesses? After the break, we'll break down the numbers for you, and we're going to see where the majority stands on what McConnell is doing tonight here. Stay with us.